This is Duke University.
Good afternoon. My name is Neil Siegel, and on behalf of the program in public law here at Duke Law School, I wish each of you a happy first Monday. The first Monday in October means the first day of oral arguments during the U.S. Supreme Court's new term, the October 2010 term. And in fact, we just finished the first day of arguments. 2 arguments took place this morning between the hours of 10 and noon. A good number of very important cases on the docket this term. The court has so far granted certiorari in 54 cases, and so the docket is more than half full. I strongly suspect there'll probably be around 80 or so by the time the court is done granting cases for this term. I have with us today my colleagues whose expertise covers various areas of law that the court's decisions cover as well, and they're going to speak to us about some of the most important cases on the docket this year. We'll start with Professor Ernest Young, who will talk about a very high-profile First Amendment case. We'll turn then to Professor Joseph Blocher, who will also talk about another important First Amendment case. Then we'll turn to Professor Kathy Bradley, who will talk about the intersection of sex discrimination and immigration law, a case that the court is going to revisit for the first time since, I believe, 2000. And finally, batting cleanup, Professor Lisa Griffin, who is our criminal procedure expert, and she has a number of cases at her disposal to talk about in the areas of the 4th, 5th, and 6th Amendments. So without further ado, we'll begin now with Professor Young.
Well, thank all of you for coming, and thanks for including me. Adam Liptak, who's the Supreme Court correspondent for the New York Times, in his wisdom has said that this is the marquee case of the term. Fred Phelps is the pastor of the Westboro Baptist Church, but he doesn't worship any God that I recognize. He and his family are the answer to the famous question, what's the matter with Kansas? They travel around the country picketing at the funerals of American soldiers killed in the line of duty, invoking these deaths as God's punishment for the United States' tolerance of homosexuality. Their protests feature signs like God hates the USA and thank God for dead soldiers. Their church also has a charming little website called www.godhatesfags.com. On that website, Phelps et al. Posted what they called an epic entitled The Burden of Marine Lance Corporal Matthew Snyder, that asserted that Matthew's parents taught Matthew to defy his creator, raised him for the devil, and taught him that God was a liar. Albert Snyder, Matthew's father, responded to Phelps in the good old American way. He sued the pants off him. Snyder and his doctors testified at trial that he had suffered severe depression, a worsening of his diabetes as a result of severe emotional distress. The trial court rejected Phelps' argument that the First Amendment categorically protected the church's activities. 3 tort claims got to the jury. The most important one was intentional infliction of emotional distress. The jury found Phelps liable to the tune of $2.9 million in compensatory damages and $8 million in punitive damages, although the district court reduced the total award to $2.1 million. The Fourth Circuit, though, reversed and held that the free speech clause protected Phelps from all liability. Judge King wrote for the panel that judges defending the Constitution must sometimes share their foxhole with scoundrels of every sort, but to abandon the post because of the poor company is to sell freedom cheaply. It is a fair summary of history to say that the safeguards of liberty have often been forged in controversies involving not very nice people. 3 questions are presented to the court. The first, which I think is the most important, is does Hustler Magazine versus Falwell, which held that the New York Times versus Sullivan standard in libel cases, which requires libel plaintiffs to prove actual malice in order to protect free speech values, does that standard apply to the IIED tort? That's what Hustler held. And the question in this case is, does Hustler extend to a dispute between a private person versus another private person concerning a private matter? That's the first question. The second question is interesting. It says, does the First Amendment's freedom of speech tenet trump the First Amendment's freedom of religion and peaceful assembly? Snyder argues that it trenched upon his free exercise of religion rights to have someone else interrupt his Catholic funeral. And then third, does an individual attending a family member's funeral constitute a captive audience who is entitled to state protection from unwanted communication? That would be a lot more interesting question if the police had allowed the Phelps people closer to the funeral. I don't think the facts really present that question very cleanly, and I don't think the court will reach it. They're likely to focus on the first question. But since I got roped into this panel on the theory that I'm teaching religious liberty this semester, and this case involves religion, I want to talk briefly about the religion claims. And there are two, actually. There's Phelps' claim that the Free Exercise Clause protected his activities. That isn't in the questions presented to the court simply because Phelps won below, but he's entitled as a matter of procedure to defend the judgment below on that ground. And then there's Snyder's claim in the second question presented that Phelps' activities interfered with his free exercise. So take Phelps first, please. The district court relied on a case called Employment Division versus Smith, which holds that generally applicable laws that burden religious exercise are subject only to rational basis review. I think that's plainly wrong. The intentional infliction of emotional distress tort is not a generally applicable law. It is applied to individual circumstances by juries in tort cases, and therefore it's, I think, subject to the older strict scrutiny standard. On the other hand, strict scrutiny isn't really very strict in religion cases. One sometimes thinks that God called his free exercise plaintiffs to suffer at the hands of federal judges because they always lose. And so it seems likely that Maryland's tort of intentional infliction of emotional distress would pass strict scrutiny because the interest in protecting people from that sort of harm are likely to be found compelling. So much for Phelps' argument. The religion question raised by the cert petition is the different one, that allowing Phelps to intrude on the funeral interfered with Snyder's free exercise. You might be tempted to get rid of that on state action grounds since it was Phelps that interfered, not the government. But just as a private tort judgment imposed by a jury is state action, I think also the court's decision that takes away Snyder's tort judgment would also be state action, so I don't think that works. But I don't think there's a meritorious claim here. If Phelps has a meritorious free speech claim, then preventing a violation of his free speech rights would be a compelling state interest for the government, and I think that would support allowing him to picket at the funeral against any religion claim. So I think the case actually will come down to the speech issues. I just wanted to ask for a few minutes why we think this speech is protected. I think the conventional wisdom is that it is protected and that Phelps is likely to prevail in the Supreme Court. I think the argument has to be something like a slippery slope argument. If you allow juries to impose damages liability in a case like this, outrageous as it is, you're likely to impose liability in cases involving a lot more middle-of-the-road conduct and speech and maybe a lot more valuable speech. That, at least, has been the argument that a lot of people have made. It's curious, though, the pervasive reliance on slippery slope arguments in free speech law. We don't buy them in other areas of constitutional law. In the area of federalism, for instance, you might say, well, if we let the federal government regulate the cost of wheat or the production of wheat, even for people who aren't going to sell the wheat, in a case like Wickard versus Filburn, then they'll be able to regulate anything at all. And sure enough, that actually happened, and yet we still don't take seriously slippery slope arguments in that area. It's unclear why they're so influential in speech law. And then the other thing that is true about slippery slope arguments is they tend to run in both directions. If you allow, here's the other slippery slope, if you allow this sort of speech, then you may be on a slippery slope to a complete breakdown in social cohesion. If people lose confidence in the ability of the law to protect what they consider to be sacred interests, like the privacy of a funeral, then people may take the law into their own hands. That's, in fact, exactly what Snyder predicts will happen should he lose this case. If the law doesn't vindicate the privacy of Marines who've been killed in the line of duty, there are a lot of other Marines out there. In any event, I think that when we allow other people to disrupt people's funerals, we're not at the top of a slippery slope. I think we're at the bottom. I think there's several possible fire breaks that are available to a court in trying to draw a principled line between this and other cases. One would be public versus private figures. That's the question that the court took the case to decide. It seems like a viable distinction to me. We have to make it in other areas. It's a fuzzy distinction, to be sure, but refusing to draw lines has costs too. A second possible distinction would be between tort and direct regulation. It's not that tort suits aren't state action. They clearly are. It's that juries are very different kinds of censors than other kinds of government officials. There's no risk of the government using its power to snuff out opposition to the government, right? The jury is not an instrument, a direct instrument of the government. This is the people regulating, not the government. And there's no continuing body with censorial power. Juries sit for a single case. So I think it's a little less risky here. You could also draw a line between matters of public and matters of private concern. Whether the United States has the right policy on homosexuals is a matter of public concern, but whether the Snyders raised their child to think God is a liar is not a matter of public concern. It's a matter of private concern. And so if you impose liability on the basis of assertions like that, then I don't think there should be any First Amendment problem. And that, again, is a line that you could draw, but the Fourth Amendment or the Fourth Circuit refused to draw that line. And then the last line that I think, well, two others, very briefly. One is the difference between the idea and the expression of the idea. It seems to me that you don't necessarily have to say that Phelps can express his ideas in any fashion possible, and whatever means he chooses and whatever language he chooses to use is protected by the First Amendment. If that were true, then copyright would be unconstitutional. Copyright relies on the distinction between protecting ideas, which the First Amendment protects, allowing people to have free access to express any idea they want, and yet restricting their ability to use any expression that they want. It seems like that's a viable line to draw. And then I guess the last point, I'll cut to the last point here. What exactly sort of freedom of expression are we saving? Because, in fact, neither you nor I enjoy the kind of freedom to say the sort of things that Phelps was saying. There are so many social, political, economic sanctions for saying this sort of thing in public. And those sanctions are swift and sure. What Rick Sanchez said about Jon Stewart last week, for instance, was considerably tamer than what Phelps said about Matthew. It was certainly protected under the First Amendment, and yet Sanchez's career is over, and perhaps rightly so. So this is not a freedom that actually most of us are able to enjoy, or that we would particularly miss, the freedom to say things like this. And I think if the court were to draw some lines here, that would be both doable and worthwhile.
Thank you very much, Professor Young. Professor Bloger.
So the case I was going to talk about is also a First Amendment case, also involves some difficult line drawing, and I think I'm obligated to refer to it as the ironically named case of Schwarzenegger versus entertainment merchants. It's a case from California involving California's attempt to ban the sale of violent video games to children. So just to, again, that sort of adds to the levels of irony here, I guess. Just to set the stage a little bit, I remember playing video games growing up, and I remember there being sort of a low-level, non-malevolent violence about all of them, right? It was Donkey Kong throwing barrels at Mario, and Mario jumping on Koopas, and everybody shooting the ducks in Duck Hunt. But it turns out that video games have evolved, and this may be, it may be no surprise to you, but for those of you who are not familiar, this is from the district court's decision, a description of the kinds of games that California is trying to regulate. This goes to Professor Young's question of what exactly is it that we're trying to save with the First Amendment. This is a description. The game involves shooting both armed opponents, such as police officers, and unarmed people, such as schoolgirls. Girls attacked with a shovel will beg for mercy. The player can be merciless and decapitate them with the shovel. People shot in the leg will fall down and crawl. The player can then pour gasoline over them, set them on fire, and urinate on them. So this is California, maybe unsurprisingly, was a little bit perturbed by the nature of the games that children in California were playing and invoked two sort of state interests in the course of trying to regulate them. One is that, and California presented some evidence for this, that children who play these games or who are exposed to these games end up engaging in more violent behavior growing up. It may not be attacking people with shovels or shooting police officers, but they may fight more, they may sort of turn to violence as an answer when they're sort of, faced with some sort of confrontation or whatever. And they presented some psychological studies suggesting this might be true. Not knockdown, drag out evidence, but some evidence, right? And they said, well, we have a strong state interest in, preventing our children from becoming these sort of conscienceless, attackers, right? Violent. And they also said, and this is the second state interest I think is maybe a little more tenuous, that playing these games creates sort of aggressive thoughts in children, and the prevention of that is a state interest. Now that I think is a little tenuous because it is is exactly being the thought police, right? Which is usually something the First Amendment would prohibit. But California passed this law which imposes a civil liability of up to $1,000 on anyone who sells or rents to a minor a video game that has been labeled a violent video game. And it goes on to define violent video game. And this definitional stuff is very important for the First Amendment, obviously. Define a violent video game as one in which the range of options available to a player includes killing, maiming, dismembering, or sexually assaulting an image of a human being if those acts are depicted in a way that appeals to the prurient interests of minors or lacks serious literary, artistic, political, or scientific value. And those words, for those of you who've taken con law or First Amendment, may sound familiar, the prurient interest, right, and the lacking serious value. And I think what California is clearly trying to do here is pick up on the constitutional definition of obscenity. Now, obscenity, you may know, is sort of like it's looked at as sort of a carve-out from the First Amendment. The Supreme Court often says it gets no constitutional protection. States can ban materials that are obscene, and the court defines them using some of these terms: prurient interest, or predominantly appeals to the prurient interest, lacks value, patently offensive, etc. Right? California is clearly trying to to pick that up in their definition. They also have, California does, on its side, a more specific precedent, which is a case called Ginsburg from 1968, in which the court said that these standards apply differently when you're trying to keep things away from children. So in Ginsburg, the law, it was a New York law, I think, banned what were, this is a quote, girly magazines, right? Not obscene, they didn't meet the constitutional level of obscenity, right? But it banned the sale of girly magazines, sexual content, but not obscene, to minors, right? And the Supreme Court upheld this and basically said that that obscenity definition, right, the what you can ban, you know, the range is broader when what you're trying to do is ban minors from possessing it. And the basic idea here is minors are not sort of fully formed participants in the marketplace of ideas. They're not ready to sort of be exposed to things like this, and therefore you have a little extra sort of room to regulate. But Ginsburg, like obscenity doctrine generally, is focused explicitly on sexual material. Right? It has not been extended to violent material. And obscenity doctrine itself covers just sex, not violence. And that's what the video game merchants, or one of the things that the video game merchants argued below and are arguing here is, look, that we've had this sort of social understanding and this legal understanding that sexual stuff can get carved out from the First Amendment, but we've never had that with violence. May strike you as weird, but that's the way the doctrine is. The Ninth Circuit agreed, and they struck down the law saying, we're not going to extend Ginsburg, right? Here, we're bound by it, right? But these games are not just sexual, they're violent, and we're not going to extend that ourselves. They also said, that doesn't mean necessarily that the law is unconstitutional, right? You guys can still argue for it. California, you can say it passes strict scrutiny, that you have, that it's narrowly tailored to further some compelling government interest, right? And so then the court turned to evaluate those studies I mentioned earlier, the psychological studies. Did California show enough of a causal connection between the sort of playing of violent video games and violent behavior? And they said, no, you didn't show enough, right? You really need to show something almost like a causal relationship, not a correlation. And those really, that sort of set up the two questions on which the court took cert, which is one, are these kinds of games protected at all by the First Amendment? Because if they're not, California can ban them. And two, if they are, what does California have to show in order to ban them? Like, what's the sort of, how close does the relationship have to be? Now, there's one additional wrinkle here which makes the case interesting, which is that it was held last term pending the court's decision in Stevens, which is the case involving the federal ban on the sale of depictions of animal cruelty. And as you may recall, there was this case last year involving crush videos and sale of videos involving dogfights and things like that. There's a federal law against it, and the Supreme Court struck down the law on various grounds. It's overbroad, etc. And then, after having decided that, then decided to hear this case. Now, probably, I think, sends the signal that this California law is in trouble, because having said that it's not okay to ban depictions of actual animal cruelty, I think it's probable that the court is going to say you also can't ban video game depictions of violence against humans. Now, the video game people, of course, are arguing, look, video games today have these narratives, right? They're like movies. I mean, they actually say they're like movies or books, right? The character development and everything, and if you ban them, then you're just going to be banning all kinds of other media, and you don't want to get into that. You can leave Ginsburg where it is. You don't need to extend this to violence, the sexual exception to violence. California is obviously arguing on the other side. This is exactly the same reasoning as applies in Ginsburg, and you should extend the exception here. And anyway, we've shown that there's this connection. You have to let us you know, you have to let our evidence in, essentially, and consider it and say that we have a good enough sort of reason here. Personally, my prediction is, given Stevens, that the court is going to strike down this law, you know, for maybe some of the same reasons that Professor Young has sort of discounted, the slippery slope kind of arguments. Also, in the First Amendment context, we have this sort of notion of vagueness and overbreadth, which is a little different from the slippery slope, but is pretty close to it, which is that when you have a definition which could be you know, that could potentially encompass protected speech, the courts tend to sort of strike down in order to sort of narrow, and that's what they did in Stevens. I predict that's probably what they'll do here.
Thank you, Professor Bloger. And Professor Bradley.
Okay, I'm going to talk about a case coming out of the Ninth Circuit as well. This one is Ruben Flores VR versus United States. It's going to be argued next month. And this is a case about citizenship and about parent-child relationships. The predecessor case that it feeds off of is one that I talk about in family law, and it's now calling into question that holding. And the question is whether Congress can impose different requirements on men and on women for conveying U.S. citizenship to their children based on the biological differences between men and women and the risk that a child will be born stateless, which is, according to Supreme Court precedent and foreign relations law and international law, a deplored condition that we don't want to leave anybody in. Now, I'll say this is not an anchor baby case, although I'm guessing that when the case gets argued next month, there's going to be all kinds of discussions, and that term's going to pop up again. In the anchor baby situation, what you would have is a non-U.S. citizen who would come to the United States, have a child here, and the child, by virtue of being born in the U.S., on U.S. soil, would get U.S. citizenship. And that's one of the ways that you can get citizenship. This is a case about not use solely, I like to throw Latin terms in just for fun, which is based on where you're born, but on the jus sanguinis, that is the law of blood, the blood relationship between the parent and child. And it's about whether a U.S. citizen can confer citizenship on a child who is not born in the United States, and particularly whether an unwed father can do that on the same terms as an unwed mother, okay? So the petitioner is Ruben Flores VR, and just to make clear, he's not a child anymore. He'll turn 36 this Thursday, but his parent-child relationship is still really much at issue. He was born in Tijuana, Mexico in 1974. His mother is a Mexican citizen. His father is a U.S. citizen, although there's some question about whether his father even knew he was a U.S. citizen at the time that Ruben was born. Because the father took his citizenship from his own mother based on her U.S. citizenship. And he, in fact, didn't have his own citizenship papers from the U.S. until he himself was well into adulthood. Now, Ruben's dad was 16 when Ruben was born in Mexico, and the age makes a big difference. As I said, Ruben's father's mother, Ruben's grandma, was also a U.S. citizen. And so when Ruben was about 2 months old, Ruben's father and grandmother took him to the United States for medical treatment. The mother consented to this, and she had no part in raising Ruben throughout his childhood. In fact, there's some indication she would have been willing to allow Ruben's grandmother to adopt him, although that adoption never took place either. But Ruben comes to the U.S., he lives here, he lives in San Diego, he goes to school, has a happy life, as far as we can tell. And Dad is the one who's the primary parent taking care of him the whole time. Now, Dad did one of the things that he needed to do, which is that when Ruben was 10, he actually acknowledged his paternity of Ruben in an official document. So there's a legal basis for proving that he is Ruben's father, and that was clear. But he didn't do it until Ruben was, into his, like about 10 years old. And as Ruben grows up, unfortunately, his happy childhood gives way to problems in adulthood because by the time he's 23, he's been arrested for importing marijuana. He gets sent back to Mexico. He keeps coming back into the United States. He keeps getting arrested, getting sent back to Mexico, and so forth. Till finally, in 2006, he's charged with being a deported alien found in violation of U.S. law in the United States, and that's what gets to this case. Now, his claim is that he's a U.S. citizen, thanks to his father's citizenship, and that the statutory mechanism that denies him citizenship violates equal protection on both gender and age grounds. Now, what the statute said at the time he was born is that a child who's born to a U.S. citizen parent, who's born abroad, could become a U.S. citizen if the U.S. citizen parent had lived in the United States for a total of 10 years at least 5 of which were after the parent had turned 14. Now this creates a problem for Reuben because his father was 16 when he was born, okay? Now that's the basic statute, but for mothers, there's another provision. And what it says is that as long as the mother citizen, the U.S. citizen mother, has lived in the United States for a year at any point during her life, that's enough to confer citizenship. So if Reuben's mom had been a citizen, he would have been a citizen immediately, as soon as he was born, and nothing else would have had to been established. Because his dad was a citizen, and because of the statutory provision, there's nothing his dad could do to establish his citizenship by virtue of the dad's own citizenship. And the dad did, like I said, the other things that he needed to do to legally establish citizenship. Now, that sounds pretty unfair, right? Like a clear violation of equal protection, it's unbalanced, all that. Well, that's what Reuben says, and he's made 2 claims. First, he says that this gender distinction between moms and dads is unconstitutional just by virtue of there's no reason for it at all. He also says there's an age-based distinction that violates equal protection in discriminating between fathers who are over age 19 and therefore could have lived in the U.S. for at least 5 years after the age of 14, and those like his own father who were under age 19, okay? Unfortunately, whether this violates equal protection is not so clear because there's a case from 2001 that is I would say it's a Nguyen case, I don't know if that's how you pronounce it or not, versus INS, where the court upheld gender discrimination in the statute for citizenship purposes. In that situation, what had happened was there was a U.S. citizen father who had fathered a child in Vietnam during the Vietnam War. He was not a soldier. He was there working for a corporation. But he fathered a child in Vietnam. He brought the child with him to the United States to live, raised the child to maturity, supported him the entire time, but unlike Reuben's father, he never did anything to formally acknowledge his paternity. Okay? And like Reuben, this Vietnamese-born child got into trouble when he was an adult. He committed sexual offenses in Texas, and he was ordered deported. At which point, both father and son say, wait a minute, this statutory scheme's unfair because what the statute does is it requires a father to do something to legally legitimate his child. There's no requirement like that for moms. That violates equal protection, okay? What the court said in Nguyen was in a 5-4 split with Justice Kennedy writing and Justice O'Connor dissenting, they said that the statute was constitutional, and they apply heightened scrutiny to the gender claim, and they say that there are important governmental interests that are served by this because they want to make sure, what the government says it wants to do is to make sure that there's a biological parent-child relationship in fact, and that there's a real connection between the child, the United States, and the United States citizen parent. And they say the reason you need to have this legitimation procedure for dads but not for moms is because when a mom gives birth, we know she's the mom. And you don't know that with dads. And so there's this gender difference here. Also, they say, you know, people travel around a lot. People could be fathering children all over the world and not know that the kids are actually born anywhere. And so then you don't want to be conferring citizenship on them without there having to be some other step to jump through. And this way you can require the father to actually take steps, act like a dad, do it legally, and so forth. Like I said, in the Nguyen case, the dad had done everything but the legal step. He had raised the child, supported him from birth to adulthood. And what the court says is, you know what, we know that might be nice to look at it case by case. The statute doesn't have to do that. It might not be a perfect fit, but statutes don't have to be a perfect fit. We're going to uphold the statute. What O'Connor says in dissent is this is ridiculous because it's discriminating between parents. And here, clearly, he'd done everything he needed to do. You had the parent-child bond. You had the tie to the United States. This statute makes no sense, and it's based on gender discrimination we should not tolerate. Okay? So that's the backdrop to this case. And the question now is whether the Nguyen case is going to dictate the result in this one. Okay? Now, I don't like to try and predict what the court will do because you never know what the court's going to do a lot of times, but I'm going to go out on a limb and say that I think that Reuben's going to lose, okay? And I think that's despite the fact that I think there's some solid points to his gender discrimination case here, and the fact that he's got a lot of amici on his side, including a lot of immigration law authorities, the ACLU, a lot of others who've made some very powerful arguments. And there are a number of reasons why I think that's going to happen. First, we've got the Nguyen case out there. It's only 9 years, 10 years old. Stare decisis counts for something, and I suspect that it's going to be hard to get the court off of that and say, wait a minute, why should we rethink that? Second of all, there's a problem with standing that the parties have raised. The Ninth Circuit glosses over it a little bit, but I think it could give the court an out if it wants to get out of this one. Ruben's father is not a party to this case, and that's different from what happened in Nguyen, where both father and son were parties to the case. And this complicates things, because what the court said to date is that what you're really looking at is the right of the parent to raise and control the child and make decisions for the child. Not the right of the child to have a relationship with the parent. And in fact, some of you may have read the Michael H. case, which deals with a California case where there's a married couple and the wife has a child with another man. And the other man, Michael H., wants to assert his right to have a relationship with that child and assert his paternity in the face of a California statute that says, no, we're just going to look at the marriage. And one of the things that happens in that case is that the child in that case tries to assert her own rights, to say, I have a right to have a relationship with my father. And the court, through Scalia, says, no, you don't. At least not at the constitutional level. We've never recognized such a right. So for Ruben to be the only party here creates some problems. He is saying that he's got third-party standing to assert his father's rights. The government has challenged that. And the Ninth Circuit, although it goes through all of the merits arguments, does basically say at the end they're not sure he has standing either. Third problem is that there are some practical reasons that I think Ruben's likely to lose, or at least there's less reason for the court to go out on a limb and find for him. First of all, the statute he's challenging has changed. In 1986, it was amended so that now it only requires that a U.S. citizen parent have lived in the U.S. for 5 years, 2 of which have to occur after the parent turns 14. And that means that under that statute, Ruben's dad would have been able to confer citizenship on him. So the only people that are likely to get hurt by the old statute are ones like Ruben who are already well into adulthood, and current kids are not going to be affected the same way. The discrepancy between the 2 years post-14 and the 1 year anytime is not nearly as pronounced. The other thing is that you're dealing with somebody who's a convicted drug dealer who's been in and out of the United States a number of times. And I don't want to suggest the court's going to look at politics here or anything, but immigration law is a hot-button issue right now. And I think that if they can find a reason to say, let's just affirm what the Ninth Circuit said and said that statute's okay, that they're likely to do that. Finally, there's one additional justification that the U.S. has offered for the statute, and that is that the risk that a child will be stateless when born. That wasn't present in the Nguyen case, and I think that that's likely to actually pass constitutional muster, although there's lots of challenges to it in the brief. What the U.S. claims is that the 1 year anytime residency requirement for the mom is important so that when a child is born, it will have citizenship somewhere at birth, okay? And the argument is that if a country bases a child's citizenship not on where the child is born, but on the child's blood ties, that it's more likely that it's going to be based on the mom's blood ties. And that's true in a lot of nations, but not in all, okay? And therefore, if a child is born abroad to a U.S. citizen mom, unless there's an easy mechanism for allowing the mother to grant citizenship to the child, there's a risk that the child will not have any citizenship at all, okay? And so that's going to protect the child. Since all the United States has to do is to satisfy heightened scrutiny here and to show there's important governmental interests that are served by this, I think there's a good chance the court's going to find that this is good enough, even though it's clearly not a perfect fit, and there are going to be kids born to U.S. citizen fathers who wouldn't be protected this way. But there are some problems with the statelessness argument. First of all, the legislative history of the statute is not clear that this is what they were looking at the time. There are a number of countries which do not confer citizenship based on the mother's blood. It may be going through the father, in which case the father's lack of ability to convey citizenship to the child is going to be a problem. The other thing is that, though, that for the fathers, you still have to do something else. you have to do some step to show paternity, okay? And if you do that, it relates back under U.S. law to the date the child is born. But you can wait a very long time to do it under the statute until the child actually hits the age of majority. And in Reuben's case, his father didn't do it until Reuben was 10 years old. So the idea of making sure that a child is protected from statelessness at birth is something you can deal with a lot more easily, frankly, with women because of the biological difference than you can with men. And that's exactly what was going on in the Nguyen case when the court is looking at the biological differences. The other thing, though, to watch out for on the statelessness piece is that one thing about it is that it is aiming to protect the child's right, not the parents'. And this is something that kind of sneaks in here, but is important because, like I said, all of the other cases have really looked at the parents' right to raise and control the child. And the standing issue, if Reuben fails to have standing, it'll be because the right to confer citizenship, if there is such a thing, runs to his father, not to him. But if you start talking about worrying about whether a child is going to be stateless and you're protecting the child, then I think you start looking at whose interests are these that are really involved here. And if you start looking at that really closely, then I think it might call the Nguyen case itself into question. Okay, but we'll have to wait and see.
Well, thank you very much, Professor Bradley. Professor Griffin.
So I want to highlight cases that are about the Fourth and Sixth Amendment, but really they're evidence cases. And they're interesting because they're illustrative of some larger trends on the court that have been evolving over the past 5 years or so. The court in general is moving in the direction of allowing in more evidence in criminal cases that is seized in violation of the Fourth Amendment, where there's been some sort of error by law enforcement. At the same time, it's moving in the direction of allowing in less evidence in criminal cases where there are out-of-court statements at issue and criminal defendants haven't had an opportunity to cross-examine the witnesses in question. And one of the things that I've been thinking about lately is why what is it about each of these categories of evidence that is appealing to certain groups on the court? And I'm going to take the Confrontation Clause cases first. They're Sixth Amendment cases. And this all began in 2004 with a case called United States versus Crawford, which really changed the scope, meaning, and force of the Confrontation Clause of the Sixth Amendment. In that case, the court declared that out-of-court statements, that is statements that are made by witnesses, prosecution witnesses, that have not been cross-examined by the defense, can't be admitted even where they otherwise fit within the evidence rules, absent the opportunity to cross-examine if they are testimonial. The court more or less left it there in Crawford, and there have been a series of cases since then trying to decipher what the court meant by testimonial. There's a little bit of historical provenance to that because the court's main concern and the point of the Confrontation Clause is not to aim at the sort of relevance and reliability concerns that the rest of the rules of evidence cover, but rather to prevent state manipulation of evidence. It's a reaction against practice of using ex parte affidavits at common law in England. And there's this long history that Justice Scalia relies on heavily in authoring many of these opinions of the idea that we're doing something other than concerning ourselves with the reliability of evidence. We also want to make sure that the government is not manipulating it, that we have the opportunity to cross-examine government witnesses in criminal cases where there's a reason to do so. But of course, there are many, many instances where the cases wouldn't be able to proceed without, for example, the kind of evidence that has arisen in a case called Michigan versus Bryant, which is going to be argued tomorrow, which a lot of people are watching very closely. And the reason that case is interesting is because in finally defining what testimonial means in a series of cases in the years since Crawford, including Davis and Hammond, the court has said, okay, a statement is testimonial if its primary purpose is to talk about past facts, to relate past events to law enforcement for use at a later trial. At that point, we actually care about the motivations of law enforcement, and when we want the person who's making that statement out of court to be available for cross-examination at some point. The court separates out statements that have the primary purpose of responding to an ongoing emergency or assisting law enforcement. in some way, in some ongoing crisis, on the theory that with respect to those statements, we're less concerned about law enforcement's motivations because it's sort of a workaday activity for them to get information from someone at a crime scene, and that they're probably not thinking in terms of how they can massage the evidence for use at some later trial. So Michigan versus Bryant really tests the boundary line between those two concepts. It arises from an incident involving a man named Anthony Covington, who was a victim of a shooting. Responding to a call, officers came to a gas station where they found Mr. Covington lying on the ground next to his car. And he told them that he had been shot by Rick and that the shooting had taken place half an hour ago and about 6 blocks from the gas station where he was. Mr. Covington, several hours later, died from the wounds that he sustained in the shooting at a hospital. And in the ensuing time period, police went to an address that Mr. Covington had given them. He only identified the perpetrator as Rick, but he gave them an actual address and said that this was the scene of the crime. So officers went to that address. They found Richard Bryant there, who was the defendant in the case, and he was subsequently charged with the murder of Anthony Covington. And it's rather difficult for the government to proceed with this case without the statements of Mr. Covington, who of course is now deceased, and the statements that he made lying on the ground at the gas station. Hello, evidence students. You all know that that is hearsay, of course. These are out-of-court statements offered for the truth of the matter asserted. There are, as we're getting to, exceptions to the hearsay rule, and one of them is for what are called excited utterances. That is, very spontaneous statements. We're less concerned about their reliability if they are made in exigent circumstances or in response to some stimulus that is very exciting, on the theory that people spontaneously are less likely to be dishonest. So there's no problem of hearsay here. The trial court let it in as non-hearsay. But Mr. Bryant then complained that it was a violation of his Sixth Amendment rights to cross-examine the statement and that it was a testimonial statement. And the Michigan Supreme Court ultimately agreed with him, and the case has come up to the U.S. Supreme Court. And in many respects, this really tests what they've been trying to accomplish with the Crawford and Davis and Hammond line of cases, because it requires the justices to tangle in a way with facts. And they don't often do this, but they've been engaged in a rather difficult exercise of modifying aftermarket this right that they announced a few years ago, and it is every term since then they have had to really deal with facts on the ground, law enforcement engagement with individuals at crime scenes, techs in crime labs, and in this case they have to figure out, okay, so without question, Mr. Covington was experiencing an emergency at the time that this was going on. He died from the gunshot wounds later on. But the issue is, what was law enforcement trying to do at that point? Did law enforcement, were they trying to help him? Were they trying to apprehend an armed and dangerous perpetrator who was merely 6 blocks away from the gas station? Or is the half hour and the 6 blocks enough distance for the court to say, at this point, they're investigating. They're trying to get past facts gathered to use at a later trial. And this is the important distinction. One of Bryant's arguments is, if just the fact that a perpetrator is still at large is enough to make it an emergency, then that's going to be the case with almost every crime scene statement, because there very often will still be a perpetrator at large. So the court has to determine, is this a narration of past facts, or is this a response to an ongoing emergency? Commentators have raised this issue hypothetically in a large number of other kinds of cases, like, for example, kidnappings. They can go on for long periods of time with all kinds of interactions between the perpetrators and law enforcement, people negotiating on behalf of families, for example. Throughout that time period, the victim is experiencing an emergency at every moment that they are a hostage, let's say. But there are many moments of interactions between law enforcement and the perpetrators where they may be more focused on gathering evidence for a later prosecution. So whose perspective matters, and what does it mean to say that there's a difference between an emergency and gathering past facts is an incredibly interesting question. And this is one of those instances where drawing the line is also, in a way, raising or lowering the temperature on a constitutional right. Because if the court says this requires cross-examination, then the Sixth Amendment right to confrontation is extremely robust and will apply in almost every case where we have crime scene statements. If they say it doesn't, then it lowers the temperature a little bit on a right that's been heating up over the past few years. One other confrontation clause case, and another very thorny issue for the courts, has been what to do about lab reports. In a case last term called Melendez-Diaz, the court held that when you have lab technicians who have done blood alcohol level analysis, drug chemistry analysis, DNA analysis, ballistics, they have to testify in court. They have to be confronted. If defendants want to exercise that right, and very often they'll just stipulate to whatever the lab findings are, but if they want to cross-examine those witnesses, they now can in most cases, and there's some procedural details of that. But again, the court's holding there is being tested in a case that they recently granted cert in called Bullcoming. And it's a New Mexico case involving blood alcohol level in a DUI prosecution where the lab technician is no longer available to testify. And New Mexico sent a supervisor from the laboratory who had no involvement in the actual processing of the blood, but could speak to how the chromatograph works, could speak to the procedures in the laboratory. And then there was debate in the lower courts about whether that was adequate. And that is another case that the court has to decide this year. Does everyone, it's always been the case that not everyone who touches a sample that comes from a crime scene has to be called as a witness, or trials would be really monotonous and long. Their chain of custody issues are weight issues, and you're not required to call every single law enforcement officer, for example, who's handled a sample on its way to a laboratory. So is this that kind of a case, or is this a case where we actually need someone who performed the analysis and not just someone who can testify to the procedures in the lab? Melendez-Diaz had 4 dissenters, and they're all still on the court. Of the 5 justices in the majority, 2 of them are no longer on the court, Souter and Stevens. So it'll be interesting to see whether one of those justices is willing to go along with the dicta that about that chain of custody issues matter here, and that we've never held that you have to be able to cross-examine every single person who has access to a sample in the course of an investigation. I don't want to be less intrepid than my colleagues about making a prediction, although I do think they are often very difficult to do. But another interesting twist on the Confrontation Clause, particularly with regard to Michigan versus Bryant, is that it's a strange bedfellows kind of situation for the Supreme Court. The general majority in expanding the Sixth Amendment right has been Scalia, Stevens, Souter, Thomas, and Ginsburg. And then Chief Justice Roberts, Justice Breyer, Justice Alito, and Justice Kennedy have often voted in the minority. So the question now is, well, what is the addition of new Associate Justice Elena Kagan as of today, and Sotomayor do to that lineup? Another interesting twist is that, of course, Elena Kagan is recused from at least a third of the cases this term, including these, because she was Solicitor General, and the United States has filed some briefs here. So she won't have a say about this in particular, and everyone's looking at Justice Sotomayor. I think she'll probably be the key in the Michigan versus Bryant decision. If I had to guess, I would actually be likely to position her with Roberts, Breyer, Alito, and Kennedy on this. She's institutionally minded in some of the same ways that some of them are. And oftentimes, when the administrability of criminal cases is a big issue, as it is with the Confrontation Clause, that tends to carry the day, and I think it may for her going forward, too. So that's my hedged prediction about how that's all going to come out. And then finally, one last case, briefly, because it illustrates the flip side of this, which is letting in more evidence, is an interesting Fourth Amendment case. This is Kentucky versus King. There have been, on the court's docket, fewer and fewer Fourth Amendment cases every year over the last few years, and lots of people are trying to figure out why that is. I think that most people would say it's because they rule against the defendant in every single one of them, with rare exceptions, and that there are some defensive votes to deny cert in otherwise meritorious cases because justices who might otherwise think the case is interesting or fruitful are going to lose, and they know that they're going to be in the minority, so they're less willing to take cases and fight more vigorously against granting cert in them. Since the 2009 decision in the Herring case, a lot of people have had their eye on the exclusionary rule. It seems to be contracting quite a bit. That was really about clerical errors. Now, in Kentucky versus King, we have the opportunity for a very broad, good faith exception to the exclusionary rule. This is a case in which the Lexington police were in pursuit of an individual who sold crack to an undercover informant. They were not in hot pursuit. The person did not know that he was being followed. He went into an apartment building and they lost sight of him. They walk into the building and they smell marijuana wafting from an apartment in the building, and they think, this is our guy. So they knock on the door, identify themselves as police, and then they begin to hear the telltale sounds of what seems to be a certain amount of destruction of contraband inside the apartment. So they, acting on their training, they're allowed now with exigent circumstances to break down the door. They do so. And they come across the very unlucky Mr. Hollis King when they do, who has nothing whatsoever to do with their undercover informant or the previous sale of crack, but is there in his apartment with a number of associates smoking marijuana, has cash, other drugs, drug paraphernalia. It's a very bad situation for Mr. King. So he pleads guilty to the drug charges, but he reserves the right to pursue this evidentiary issue on appeal, and he has done so. And the question the court now has to answer is, well, the police kind of created that exigent circumstance because they were smoking marijuana, the police smelled it, they knocked on the door, but they weren't in hot pursuit of anyone. They weren't actually supposed to be targeting that particular apartment. Yes, probably some contraband was being destroyed after they identified themselves as, police open up, but they had actually created the exigent circumstance. So are we going to extend this idea of this possibility that there's a good faith exception, that if law enforcement errs, we don't want to punish them for that, to say there's no exclusion of the evidence in this case? And it's also a fact-bound case. So probably the most interesting question about it is, why did they take it, if not to extend hearing and to cut back more on the exclusionary rule? So we'll see.
Well, thank you very much. Professor Blocher mentioned the Stevens case, U.S. against Stevens, which involved a federal law prohibiting so-called crush videos and other forms of animal cruelty. The program in public law actually sponsored a moot of that case last year. Patricia Millett, who won that case on behalf of Mr. Stevens, mooted the case before Duke Law faculty, and that is a shameless segue into tomorrow's public law event in which we're going to have a moot and a pending case, Skinner against Switzer, which involves the question of access to DNA evidence, to biological evidence, and specifically whether a convicted prisoner who's seeking access to biological evidence for DNA testing may assert that claim in a civil rights action invoking Section 1983, or whether such a claim may be asserted only in a petition for a writ of habeas corpus. And so if you want to see the actual lawyers who are going to be arguing the case soon moot the case before a collection of my colleagues, I do encourage you to come. We have about 8 minutes left. There are a number of important cases that we haven't covered. I hope this will whet your appetite. Some very important preemption cases. Some very important cases involving the rights of corporations, prosecutorial misconduct, establishment clause challenges to an Arizona tax credit program. So I do hope you will pursue these cases over the course of the term. The question I want to ask my colleagues as we come to the end is, what do the cases you've talked about or other cases on the docket, what do they tell us about the kind of court the Roberts Court is? So in the First Amendment cases that Professors Young and Blocher talked about, I can't think of a way to split the court up ideologically. I can't think of it. There's a lot of. It doesn't seem right to carve the court ideologically in First Amendment cases anymore, outside the campaign finance context, right? If we talked about preemption cases, I think that makes for strange bedfellows. If we talked about the Establishment Clause, I think it makes more sense to talk about liberals and conservatives, right? Criminal procedure, maybe with respect to the exclusionary rule in the Fourth Amendment, but not with respect to the Confrontation Clause, right? Sotomayor was with Breyer and Ginsburg 90% of the time last year. She can't be with both of them when it comes to the Confrontation Clause, right? Sex discrimination and immigration law, I don't know. Maybe that is going to subject itself to more of an ideological parsing, but maybe not. I just don't know. So what kind of court are we dealing with? How would you carve it? And does it really just depend on areas of law? And if so, why do certain areas of law tend to trigger certain kinds of splits and others don't?
Well, I think in the speech cases, it's a radically pro-speech court. And Justice Kennedy, who, if you did have the traditional split, would be the swing vote, wrote an opinion a couple decades ago now, arguing that strict scrutiny for restrictions of free speech was not a protective enough standard, and you should have a categorical prohibition on government action that restricts speech. You shouldn't even balance under the compelling interest standard. I think it's an area where the conservatives on the court show how pro-civil liberties they are, and The liberals on the court are pro-civil liberties, I guess. I mean, I wish it were more interesting than that. I think a case like Phelps raises a really interesting question about whether the obsessive protection of free speech is really kind of a self-serving value of the chattering classes. You know, lawyers and media people, they all speak for a living, so of course they elevate that value above all else. People who make things, people who fight the country's wars, maybe they don't think, you know, speech is the most important thing. But I think this court sees speech as a transcendent value, certainly more transcendent than religion or basically any other constitutional values. I think you're likely to see that pattern continue.
I think the same thing's going to be true in Schwarzenegger. I mean, Stevens was an 8-1 decision with Justice Alito dissenting. I don't know about Schwarzenegger will be quite the same, but I think the court will find, you know, protection even for these violent video games, which when you back up and think about it, it's hard to imagine how they advance the marketplace of ideas or self-governance or, you know, individual autonomy or any of those other sort of, you know, benefits that we associate with the First Amendment, but I think the court will protect it, and there may be good reasons for that. There may be reasons that the court should allow more regulation, but I don't expect to get a lot out of the First Amendment cases. The ones with a real political valence are the ones that have political sort of importance outside the court, like Citizens United and things like that. And maybe these should, but I don't think they do.
Okay, great. All right, let's. We have 5 minutes. Questions about any of these cases? Any other cases? Yes.
What do you think Kagan's recusal and at least a third of the cases are going to do in terms of leaving a handful of areas of law unsettled come June?
It'll be unsettled if they split 4-4, in which case the lower court judgment will be affirmed by an equally divided court, but the decision will not have any precedential effect. There's interestingly some movement in Congress to try and have living retired justices sit when a justice recuses. Right. I don't know if that's going to go anywhere politically in light of who the living retired justices are. But nonetheless, there's some concern about this. There's also some concern to have justices divest themselves of stock that would get in the way of them hearing cases. For years, this was a problem with Justice O'Connor and to some extent Justice Breyer. So if they split 4-4, that'll leave particular areas unsettled. I'd like to think they'll take some effort not to split 4-4 if possible. But right now, it's about half the cases they've taken, right?
The question assumes that a Supreme Court decision will settle the law.
To rephrase the question, will the court splitting 4-4 by an equally divided, affirming by equally divided court, will that leave the law more unsettled than it usually is when the Supreme Court splits 5-4 or 9-0? Other questions? This is a short-term thing for Kagan, right? This is about half of the 54 cases they've taken so far. Beyond this term, it's not likely, well, beyond this term and the next, it's not likely to be a big problem. And then it's the more garden variety recusal problems. Another question? I'm missing a hand somewhere. Right. Oh, hi.
Liptak in the Times last week mentioned that Roberts Court, again, has taken a large percentage of cases with the corporate party. And I wonder if you anticipate, kind of with the new dynamics of the court scene, kind of the, I don't know what you want to really call it, reverse activism kind of trend continue, or if Kagan and Sotomayor will be able to shift things in a different direction.
Well, yeah, you know, the question is, should we use the term activism at all, and what does reverse activism mean as opposed to just activism, but in the hands of other justices? You know, this is so freighted with politics and ideology. So I think what I'll just say is use your question as an opportunity to mention another case or two on the docket this term. So FCC against AT&T, right? It's not Citizens United. It's not as big a deal as that. But nonetheless, there's an exception in the Freedom of Information Act for personal privacy, right? And the question is, does the personal privacy exception to the FOIA, Freedom of Information Act, apply to corporations, right? Do corporations have personal privacy under the Freedom of Information Act, or does it make no sense to think of them as people? That's going to be an example of a case in which we'll see what the court does, right, and how the justices carve themselves. Now, I think what's going to happen, which is what always happens, is people are going to infer lots of things from one decision and make very broad statements about the Roberts Court and corporations, which is always a hazardous thing to do, but that's an example. There are a number of important preemption cases in which you have corporations wanting federal law to govern because they do better under federal law than they do under state law. And the question is, for example, whether or not AT&T can require consumers to agree not to pursue class actions and arbitration agreements. This is AT&T Mobility against Concepcion. It's a fight between the Federal Arbitration Act and California contract law. Right? So other preemption cases in which we're going to see how the justices carve themselves, what conception of corporate personhood do they have in mind.
If I could just add one thing.
Yeah, sure.
I mean, there's two sorts of questions that statistic would implicate. One is the Roberts Court going to be more friendly to corporate interests in cases where those are represented? And the other is it going to be more interested in classes of cases where corporations are often present and often suing each other? When John Roberts was nominated, he said one thing I really think is important is to have more federal statutory, antitrust or intellectual property or securities cases, all these business areas. Doesn't necessarily mean the corporations are going to win those cases, but I think he's absolutely right that, I teach con law. This is against interest, but it ain't necessarily the most important thing all the time.
Just almost all the time.
Just in my class.
Right. No, but the number of corporate business, commercial securities cases, right, they become more and more, and traditional con law, right, is not a big enough blanket to cover the bed that is the court's docket. Okay. All right. Well, thank you all for coming. Thank you to my colleagues for very illuminating discussion.
Produced by Duke University. Online at duke.edu.